Miss Mwai and Miss Omoyo.
Miss Omoyo.
Yes.
Okay.
And I'm told Shadrach Wambui is joining. And also,
Okay. Just introduce the ones that are there. Yes. For the forum purposes, I'll go back. And then I'll do the details. Yes. This is just for introduction.
Oh, fine.
Okay. I'm going to Cora first. We have Mr. Ochoki. You are alone, Mr. Ochoki?
Yes, for today I'm alone. With two very able assistants who unfortunately can't go in because they've not been admitted.
Okay.
Yes.
Mr. Moturi, you are with me? Oh, you are alone?
I'm alone, yes.
Eric Moturi for the first and second.
First and second.
Mr. Eric Moturi. First and second. That is who is the lead counsel, Mr.
My
Nyamira?
Lord, I'll be the lead counsel.
Mr. Nyamira.
I'm assisted by Betty. That is Miss Maya,
Ms. Mwai.
Mr. Moya,
Mr. Moyo.
Mr. Mokua, Betty.
Sorry?
Mokua.
Sorry, did you say Betty? Oh, there is Mokua and Moyo.
Yes. Which one will be?
Mr. Moyo.
Miss Maya,
Ms. Mokua.
Mr. Mokua.
Oh, Mr. Mokua. Sorry. I'm sorry.
Then Shadrach Wambui.
Good morning, Your President.
Then shortly we'll be joined by Adela Suma.
Thank you for that. I noticed before we embark on the hearing, there is a notice of motion dated 23rd November by the first and second respondents emanating from the ruling we made last when we were here on the issue of securing the warehouse. From my reading of the application is like there is a challenge. Maybe before we formally hear the application, may I know how many regions use that warehouse other than Nyamira, Kisii County? Is there any other county, Mr. Moturi?
I'm told the warehouse is used by Nyamira and Kisii.
Nyamira and Kisii counties?
Yes.
There is an ongoing petition in Kisii?
There is, yes. Not even one, I think. There are two petitions.
There are two petitions?
Yes. I also understand there are petitions for MCA in this court. There's one.
No. For this court, there will be no issue because the year is one.
Yes.
That's why I'm trying to find out.
Yes.
So that when we come to addressing that issue, we have facts. You know, some of these things, unless we have the facts at times, we may not render a very good ruling.
Yes, my lord.
So we have two dealers who will, if we go by our previous order,
Yes.
will require 2 years to have access. Eh?
Yes, my lord. The mode of access was also a challenge. The mode of access. My clients.
Okay. Maybe this is just informal.
Yes.
First, before I ask you to address me,
Yes.
because I just wanted to appreciate
Yes.
the challenge that is being appreciated on the ground.
Yes.
Before I ask you to take 5 minutes each to address me on that issue, so that we may agree, unless parties have agreed. Mr. Moturi?
No, I'm just consulting my friend. What I believe probably would be the right thing in our view of the record is for my learned friend, for the petitioner, Mr. Choki, to maybe communicate to us the 20 stations which he believes would lead to scrutiny. And my client's instruction is that they will be willing to ask them to place extra seals on the respective ballot boxes for those 20 stations. Yes.
So that we do not belabor their application.
Yes.
I would think that would be the best if is agreeable, because our ruling was informed by, we had in mind that there is an application that is pending for scrutiny and for recount. Recount, we didn't have an issue. In a recount, there is no issue. Because scrutiny is very, especially those of you who have been involved before, you know we start scrutinizing the votes from the top. So that's why I was thinking if we did add seals, it may complicate. But if we are all agreeable, then I have no problem. Mr. Ochoki, I don't know, off the record, can you?
No, my lord, actually that was our application that will place extra seals. We are grateful for the concession.
Yes.
And possibly that will help in a lot of ways by just placing the extra seals in those ballot boxes. So I'll be happy to concede to the application in terms that we'll be allowed to put extra seals.
Let me now capture it so that we don't belabor.
There is also Mr. Nyamira.
Yes. This was off record.
It was off record.
Now I want to do it on record. You want that to go on record?
Right of that cherry. My Lord, what eventually we'll be dealing with is the recount, because the scrutiny aspect, I think, when we were doing the first trials, he ably informed the court that he was not going to go that line of scrutiny. So it's a recount, perhaps.
I don't know. I do not want to appear to. You know, mine was persuasion because of knowing what scrutiny means. Unless it's for limited stations.
And he considered the first time we were in court, yes.
So let me just.
My lord, I never conceded. Let it go on record. That
I know it's not even on record that way.
our application is yet to be heard, so I could not concede on an application, my lord, that has not been heard.
That is just by the way. Yeah?
Yes.
You're like over record.
I'd seen it somewhere in Mr. Nyamira's submissions, so that it better comes out clear, my lord, for the avoidance.
Okay, let's just deal with the matter at hand now, which I'm happy that parties have agreed on the best way forward. So how do I put your application, Mr. Moturi?
My lord, I think the consent would be that the application dated the application dated.
Sorry, I want us to first of all capture that we are experiencing challenges in abiding by the ruling of which dates?
The ruling of 18th
of 18th
November.
November. And you have a consent.
And we have consented that the same be marked as compromise on the following terms.
Your application is dated
23rd November.
Yes.
On the following terms, my lord, that the petitioners to provide
Is this petitioner?
petitioner.
Petitioners or petitioner?
Petitioner.
Yes, to provide
a list of the 20 polling stations as named or identified in the petition to the first and the second respondents for purposes of being allowed access under the supervision of the first and the second respondent in order to place their own extra seals in the ballot boxes
In the or to the?
to the No, my learned friend is, which is good, is indicating that it is the court to place the seals, but I thought it was the other way around.
It was the beer, my lord.
The court has seals.
Is the PR, sorry that I'm interjecting.
No,
It's
no.
the PR of the court that was to put that exercise here, because the orders of 18, but that the DR in liar, yes,
Yes.
the seals, not the petitioner.
But it can be done in the presence of the petitioner, yes? Because, you know, both all the parties, because the petitioners are the interested parties here. So I think it is important for their presence, even if the DR will be doing that. So we
say the deer.
allow under station in order the DR, order for the DR.
My lord.
Yes,
I
yes.
don't know whether that will be in order.
Oh,
Because my proposal is that, because initially when they're objecting to the application, they had said, if you allow it, let them place their seals. So the best thing I think would have been that the petitioner places the seals, the respondent or the third respondent, if he wishes to, places the seals. That way will be easier,
I
rather
think,
than burdening the DR with a lot of unnecessary work.
Why don't we give you 2 minutes? You come up with an agreed, so that we don't keep amending it as we write.
No, my lord, we are good. Let them place seals and the respondents place seals. Because the deer, I think, may not be able to have the seals ready as of now.
Extra seals to the boxes.
Yes,
We stopped when you were talking of in the boxes.
to them.
And it should be to the
Yes,
boxes.
to the boxes.
Okay, let's proceed. Ilikuja na meli. Haya, tuendelee.
To the boxes. I don't know now, you have to read for me, my lord.
All I've said is, or rather, all I've written is what you told me, that the petitioner produced a list of 20 polling stations as identified to the, as identified to the, does it make sense? Okay, let me read first. As identified to the first and second respondent for the purposes of being to be.
No, as
No.
identified in the petition.
Oh, in the petition.
Yes.
Oh, sorry. In the petition, yes, I think that was missing. Petition. Okay, for the purposes of being allowed under the supervision of the first and second respondents in order to place their own extra seals to the boxes.
So then we'll have to indicate, to amend a bit and indicate the respondent, the third respondent.
Yes.
To be at liberty to place their own seals too. Because we don't want to go back to the.
Yes. respondents to be at liberty to place their own sins
I don't know, my lord, whether I missed the word 20. There was there 20?
20, yes,
Yes, 20.
Yes, yes. So I should also indicate that these are consent amends the ruling of 18.
Yes.
So that it
It is
does
reviewed,
not
yes.
appear
Yes.
like we have two orders that are contradictory.
It is actually an application for review, so you're correct.
This consent amends the ruling of 18. You are all happy?
We have been alone.
Okay, let's now then embark. Oh, okay, sure, sir. Let me just say that is the order of the court.
Yes.
The consent. Okay, let me just ask for the purposes of record. You know, it's Mr. Moturi who participated there. Let me hear Mr. Ochoki.
I confirm the terms of the consent as being true reflection of what we have done.
Consent. Mr. Nyamira.
I also confirm, my lord.
The consent of the parties is adopted as the order of the court.
Thank you, my lord.
Most of them.
Mr. Ochoki, now the ball is in your court as far as that is concerned. Now let's move on to the next stage. As you are happy with you want.
Yes, it's my lord.
Yes.
We wish to tender. We requested the gentleman in IT, the court, to possibly process that.
You will require that at what stage?
Because we are adapting. I don't know, and we may need to agree at this stage, my lord, whether I may need to clarify anything in the petition or just adapt. Because I believe we've taken directions that
I thought the best practice has to adapt. Once you do that, you
that's what I intend to do.
after cross-examination, if there is need for clarification.
I was just requesting, I don't know whether we will be able to have you and my colleagues
How long will it take?
at most 5 to 10 minutes.
Can you check that?
My lord, I was going to propose, I saw there was an objection to the video, so that we can move on with the petition. I was going to propose, subject to the court's direction, that we hear the testimony. Then at the tail end, the court can make a determination whether or not to have the videos.
Okay. I remember there was an issue that was brought up during
Yes,
the
my
ruling,
lord. Yes, yes, indeed.
which I said it was premature.
It was essential, but now, my lord, this
Yes.
is the dilemma we find ourselves in.
Yes.
If Mr. Ochoki is going to usher his witness to ask for cross-examination, it will then mean that everything as presented has been admitted in evidence as exhibits before we now start processing in cross-examination. These videos, some of them are in the local dialect. We have no
Let's
transcription
do
of
this.
this.
Okay, I get your context, so that we do not belabor the point. Mr. Ochoki, as you guide your witness, lay a foundation for whatever evidence you want. Then, if they say they object, then that would be the point for me to record a ruling.
Because the issue, my lord, was
Yes, yes.
because when we did the trial, we agreed that he was only to introduce his witness
Yes.
and adopt that which he has written in the affidavit and the pleadings, then he ushers the witness to us. Now, the problem I'll find is that if he ushers this witness, it will mean that everything as presented and as placed in court has been taken in as evidence.
Sorry, maybe I thought I communicated. Probably I did not communicate what was in my mind. My communication is very simple. Probably I did not bring it that simply. You know, when we object to production of evidence, is at the time a party opts now, I want to introduce this as evidence. That is when the other party, I have an objection. So my intent is, even as he lays and he begins his preliminaries, because he knows this is a contested issue, you should lay a foundation on that you intend. Because I do not want a scenario where I'm told adapt all the exhibits as exhibits. So you lay a foundation, Mr. Ochoa, and whoever is going to lay you lay a foundation so that if there is any objection by the other party, they can object that.
No, I'm ready.
My Lord, I'll be seeking the court's
Yes.
on how best I lay a foundation without possibly the witness referring to that video. There are 3 very short videos. So that my proposal, my Lord, would have been that my colleagues object as we play them, because I do not think they have objections to the 3. 2 of them
You see, it's not, you know, we are not deviating from the normal way we take evidence. All we are saying, because of the modern way we have adopted of adopting statements, you lay a foundation when it comes to that bit of evidence, and not only the video, but any other material that you want your witness to rely on. Let him mention, I have videos, I have this and this evidence which I want to be adopted as evidence. This is when the other party is now, there's the court, we object video.
Thank you, my Lord. Actually, they just whispered that they have no objection to any other document save for the videos. So
They speak for themselves. They are great. Let's just let the witness respond.
My Lord, with your very kind permission,
Yes.
before this particular witness is sworn in, I'll be requesting that if there is any other witness in this matter, to kindly step out.
Mr. Ochoa, are your witnesses in court?
they are not actually even within Nyamira.
Leo ni huyu peke yake.
Leo ni huyu peke yake na mwingine pengine mmoja. So they are not
They're supposed to be outside, and that's why I don't, because you guys are seasoned, you have told your witnesses to remain outside.
My Lord, there is only myself and Mr. Moturi for the petitioner, first and second respondent. I'll be requesting that my colleagues speak through one of them, rather than just having everyone come and...
No, you know, we have not started business yet. When we start business proper, that is when we say we have to have a head council, and should they agree, you know, at times they come in a matter and they would want to divide their work. That way we cannot prevent. As long as they don't agree.
That's fine, my Lord.
Yes.
I'm ready.
As long as we stick to our time, you remember we agreed on time, right? Yes. So let's swear the witness and your time starts. We agreed how many minutes? 2 hours at most. Sawa. Swear the witness, please. Just read there, please. Just read there so that.
I swear by the Almighty God that the evidence I shall give before this court touching matters in question shall be true, the whole truth, and nothing but the truth. So help me God.
tell the court your name.
My names are Rodgers, Moturi, Nyamira.
What do you do for a
Just a
living?
moment, just a moment. Yes?
My name,
No. What is the name?
What do you do for a living?
I'm a businessman.
And where
Just-
do you?
just a moment. I'll do the long hand there, because we are not trusting these gadgets. Here they have witches, and before you even get the transcription back, it may take time. Yes, you are businessman, Mr. Moturi?
And where do you stay?
I stay in Nyamira.
Confirm that you are the petitioner in this matter.
Yes, I'm the petition.
Which contest, which electoral contest are you challenging?
Member of National Assembly,
Or which area?
West Nyamira.
Just a moment.
Confirm to court that alongside the petition, you have sworn an affidavit in support of the petition. Confirm the date of that affidavit.
On 5th September 2022.
Yes.
Confirm to court that you wish to wholly rely on the petition and the affidavit as your evidence in court. You wish to adapt this affidavit as your evidence in court.
I wish to adapt it, save for some few issues
Yes.
that I wanted to bring forward
Yes.
before we proceed.
Yes.
We are proceeding.
Number one, what
Yes.
is said,
Yes. Just
there
proceed.
is a summation error on page 31, paragraph 26. The hope ought to
There is
be
a what error?
a summation error, additional error. Additional
Oh,
error.
additional error.
Yes,
Additional or an additional error?
an additional error.
Okay.
Very good.
Yes.
In page 31,
Just a moment. On which page?
31,
Yes.
in paragraph 26,
Yes.
the total needs to be, ought to be 14, not 15,
That's
as
fine.
indicated.
Or to be 14, not 15.
Yes.
Okay.
And also, there is one wrong form for MCA,
There is?
one wrong form that was attached for MCA from Borabu, Nyansioko Ward. The Yinga Primary School attached by mistake.
Which page of the
The
petition?
page is 148 of ORM 1.
Page 48. You said O, R?
M-1.
So you're telling the court that that form was filed in error?
That was an error.
2148.
Sorry. Is it 40 or 148?
148.
Sorry, I got it wrong. Okay. Is it 148?
It's 147.
Page 147. Okay.
That form should not be on record, it's there by mistake.
Yeah, you have already said that.
Paragraph 33 on page 32,
On page?
on page 32 and 33, it should read as follows.
So what are you amending?
problem with that.
Yes.
Because now we are taking this evidence. I think, other than the issue of summation,
Yes.
which the court can reduce by looking at it, I do not think that you can amend an affidavit. Because an affidavit is evidence.
Is that? Okay.
Because he says now he wants to say that this paragraph should read this way, not that way. That is amending evidence.
Actually, what I was trying to do, I was telling it was a typing error, and I wanted to read the whole statement, but I can go straight to the typing error that is there. And you know, when they
Okay.
typing over, we change meaning.
Does that still hold on so that I can
But all right.
Yes.
Let's hear what he wants changed,
Yes.
so that we can be able to know. Is the mode in which he started, he said, this paragraph should read this way.
Just indicate the error so that we move
Just
to the
indicate
further.
to save on time, just indicate what you was erroneous, a typo or whatever, so that the court can note. We're talking on page 32.
32, 33. The mistake was where no scrutiny and recount was conducted. On the last 4 or 5 words of the sentence.
What was the correct, what do you propose ought to have been indicated there?
It was, Ritari was presented before this group.
I'm not following that.
I'm also not following that. I'm not following.
It's paragraph 33, my lord, of the petition, the last sentence. Of
Yeah,
that
you said the
petition.
last 5 words of the sentence.
Yeah, where it says no scrutiny and recount was conducted. So that the correct amendment ought to have been where no scrutiny and retally was presented before this court.
Instead of conducted, it should read.
Presented before this court. Because no scrutiny and recount has been conducted. That was the error.
Instead of conducted,
Yes. Presented before this court.
it should read.
Should really read where no scrutiny.
Mumepata nini?
We will object to that.
Oh, it's okay, but let me hear what you say. Presented to the court.
Yes.
I noticed only one word which.
Yeah,
if
in it, my lord, we indicated that where no scrutiny and recount was conducted. We all know there's been no scrutiny and recount
So
conducted.
let's not amplify so much, because for me, I noticed only one word which he has an issue with. That is conducted and should be replaced by the word presented.
Yes.
No.
Instead of recount is retally.
Oh,
Was
retally.
presented.
Sorry.
Retally was presented before this court.
Retally.
Yes.
Yes?
That's all. That,
Yes, Mr. Moturi, you.
Yes, on behalf of the first and the second respondent, I wish to object to that form of amending evidence on grounds that the word that the witness wishes to substitute is retali. My lord, retali is a word of art which is used under election laws with meanings as interpreted by courts. If my client had received a petition indicating that part of what they are accused of not doing is a retaliate, they would have responded appropriately. My Lord, if that evidence or amendment were to be allowed, then my clients would be prejudiced in that they will not have responded to that accusation or that ground of the petition. We therefore submit that that part of the amendment of the affidavit ought not to be allowed.
My Lord, I associate myself with submissions as done by my senior, Mr. Moturi. And I add the following, my Lord. My Lord, today was slated for the hearing, the start of the hearing of this petition. We have done pre-trials and we are past that stage of pre-trials on any amendment or any application that should be presented for analysis before the court. Pleadings in this petition are closed.
My Lord, to save on time, let me concede and abandon that proposed amendment, but I'm sure it's going to come the other way very soon, before we are done.
Let me just indicate. I wish to concede.
I am conceding, my Lord.
And abandon the same.
Yes, that particular amendment in paragraph 3 will proceed the way it is.
Yes, let's proceed then.
Thank you, my Lord. Now, just confirm that in your affidavit, you have produced, you wish to produce all the documents in the affidavit as part of your evidence, save for the 3 videos for which my colleagues have issues with. Is that correct?
Is that correct?
Okay.
How are we working? I think it's important that we mark them. Mr. Top, the other documents.
My Lord, they are...
Going by the way you have marked them, we can, I don't know whether you've done.
Yes, if you
How
allow
about-
me then,
Sorry?
if you allow me then, he can identify the documents and produce them. Though I just wanted to have them produced as lump sum, as they are marked in the affidavit.
That's what I'm
For purposes
asking.
of record.
This is what I'm asking. How we wish us to have them marked. Because we have, sorry, we cannot just say exhibit produced. We have to mark them as exhibit number 8, oh sorry, 1, 2, and 3. Unless there is any objection from this end.
My Lord, my suggestion could be
Yes.
that since they have been identified, they are next to the marked ORM.
Yes.
That is Rodgers Moturi initial.
Yes.
1, 2, 3, up to I think 6.
Precisely, this is what I'm asking.
Yes.
So that we mark them in that sequence,
So-
except for the ones that have been contested.
That's fine, my Lord. If it's not be too much, then you can identify each of the documents.
I think we are reading from the same script. I don't know why, again, you have turned and again and say you want to repeat.
Because my take would have been that we just have them, my Lord, produced as they are. But if we can be allowed to have him produce.
For the purposes of record, I would want to know what exhibit 1 is.
Okay.
And this is why we are saying it's so simple. We mark the ORL, oh sorry, it's OR
OR
1, 2,
M1.
Oh, it's ORM.
That's fine.
So
Oh,
I think I missed an M somewhere. ORM.
That's okay, my lord.
So, for clarity's sake, we just want to know there are ORM
That's
1, 2, 1, 2, which number?
1, 2. There are also A, B, C. in the
It doesn't
conference.
matter.
Yes.
Because if it's 1 and it has A and B and whatever, there will be exits in that respect. The only issue is the contested document. There should not be in between them.
Okay. Then, my lord, it's
I thought you have your list.
ORM,
Just a moment. Mr. Moturi, I thought you have a list. So that we save on time, you just look at your list. You tell us it's ORM 1 to 90.
my lord, it's ORM 1 to 5.
Okay, Mr. Moturi, I can see.
Yes, my lord, we may have a problem with that. Because
Yes.
when you look at the exhibits, they are paginated. For instance, if I look at my ORM3A,
Yes.
it has almost 100 pages.
Yes.
So I was thinking the most appropriate way, subject to your guidance, is to say exhibit ORM1, which starts from page 36, then on to the last page, so that when we are doing submission, we are,
Do we need to indicate the number of pages?
yes, because when you look at ORM1, it has 2 documents.
Yes.
No, it's one document.
Yes.
ORM2A is one document. ORM3, is it 3? 2B is 1 page, but there's one OR which has many pages.
What I'll do,
Sorry, let me understand where they have an issue. Because I thought if it's ORM1, be marked as exhibit 1.
Yes.
If it's ORM2, which has A and B and C,
Yes.
for example,
Yes.
it be exhibit 2,
Yes.
A, B, and C,
Correct.
without us marking the pages.
Yes. But now you will find
Yes.
one which has 100 pages that
Yes.
is paginated
Yes.
and is not marked A, B, C.
Oh.
Yes. So that is what I was saying, that indicate the pages.
Okay. Abundance caution. I can see.
no, my lord, I was doing it senior.
Okay.
Senior here. I can try doing that. Possibly, we can take directions as we proceed.
Okay.
Yes. Now, confirm to quote which documents, petition, which you wish to produce.
ORM1,
ORM1,
it's a copy of your national identification card,
a copy of ID.
copy of my ID, page 36. ORM2, A, B, and C. These are membership certificate of nomination and IBC clearance certificate.
Oh, these are certificates.
They run from page 37 to 39.
Page 37 to
39.
Yes.
ORM3, A, B, C, D, and E. These are the 5 results for the 5 wards in Western Uganda.
On which page are they?
They are Is that at page 41? to page 210.
Yes. No, it's not. Sorry. Is there a challenge somewhere?
Sorry,
Oh, okay.
There are 5 wards we classify them as A, B, C, D, E. So,
Yeah, it's okay. We are together. Let's move to
So, my lord, this completeness of the record,
Yes.
so that we don't necessarily object. I think that is why you should expand that which was for the Morabu, because it's going on record. There is one for the MCA position, there also, so that this is the opportune time to remove, go back and forth in object.
Yes.
That's fine, my lord. That one was at page 147, my lord. It can be expanded to page 147 from the record.
The document at page 147.
Yes.
Yes.
RM4.
RM4.
It's a copy of Form 34P, 35P.
P or B.
B proposal. It runs from page 211 to 213.
You know what I'm asking you? You know we write very fast. What is the right P? Without so let's move on
Should be 215, my lord.
to 250. Umesema 213 na wao wanasema 250. Just confirm
250.
250. Okay.
And then ORM5
5.
is a copy of the sale cassette notice, which declared that respondent as the winner of the grant. It runs from page 216 to 221.
Yes.
And then we have ORM6, is a flash disk containing the videos.
If we are producing the others as exhibits, these can be marked for identification, my lord, as MFI ORM6, MFI 6, I guess.
And flash disk. We don't have any, we don't have anything else that we have marked.
Yes. So that can be marked as MFI1, my lord.
MFI1.
That's correct.
Yes.
ORM7 copies of forms 34P, 35P,
Copies of
form 34P,
B.
yes, P for boy,
Okay, sawa, tunaelewa sasa. But
35,
remind us so that we don't write P, right? We can write 35, 34P,
35P, 36P, Samaro kwenye Matuta Ward, 37P, 38P, and 39P. They run from page 223 to 243.
Ms. Moy, kindly have your mask on. We need you longer to serve.
My Lord, and this can be Exhibit 6 now that we marked, this series can be Exhibit 6.
No, don't worry, we are, I'll just make a final whatever, just let him enumerate it.
Oh, fine.
So that we know we have one that was marked for identification, that is ORM6. So we know we shall skip.
That's fine.
So it's 7.
That's now we are going to ORM8.
Sorry.
No, I'm saying so that the record, that will not be exhibit 7.
You know that they have, no, which one?
The one is the forms, like the 4B series.
No, it will be exhibit 6.
6, okay.
Because we love skip. You know, I know there is that practice of marking them as they are, and then when something is objected to successfully, you wonder, where shall I get another to fill is? So I ordinarily go by what is produced.
Thank you.
Okay, let's move on. ORM 8.
8. These are copies of that 6B of township ward
Copies of Form 6B.
of township ward
Township.
and Form 35B of West Mugambo constituency.
Sorry,
Pages,
sorry, 34B of West Mugambo what?
constituency. It runs from
Page
244 to 248.
yes.
ORM9 Form 36P of Nyamira ward and the Form 35P of West Mugambo constituency. Yes.
And Form 36 of
West 35P of West Mugambo constituency. It runs from
pages
from 249 to 253. ORM 10, Nyamira ward, Form 35P. From page 2,
just a moment.
254 to 259.
Yes.
Or
You know that, my Lord, about the pages?
Yeah, I
254
did.
to 259.
I did.
Thank you.
If I don't get it, I'll say.
ORM 11. That's now our independent tally. It runs from page
Pages
260 to 288.
Yes.
ORM 12. It's a breakdown, summarized tabulation of 34As, highlighting the deviation.
Breakdown summary.
Summarized.
Oh, I thought it's the same. Summarized.
Is a breakdown, stroke, summarized
Just proceed.
tabulation of 34As. 35As.
There's a
35
lot of squashing. There's a lot in squashing, but the council can.
Can just assist, but don't
Okay.
be part of the evidence so that I don't get.
My Lord, paragraph 31 talks of 35 days. So that sometimes, you know, from 34 is popular, very popular thinking. That's when I was just getting to it.
35As, highlighting the deviation of votes from all aspirants.
Okay.
From page 289 to 293.
Yes.
Now,
Sorry for that.
No, just confirm that you wish to adapt all those forms as your evidence, as exhibits in this court.
Yes, I confirm, same for the videos.
Okay.
Here to the same.
Do you wish to play the video?
Let me indicate that now we have exhibit 1 to 11. Documents produced as petitioners exhibit 1 to 11. Respectively.
Now, you've adapted your evidence in court. Confirm to court that you'd wish to play to the court the videos, explain the circumstances.
The different videos.
There are 3.
I think the best thing is so that we do not lump all of them. In any case, we cannot play all of them at the same time. Let him indicate which one he wants to play, then I'll hear if there is an objection and what is the basis of the objection. So that we don't just lump them all together.
Thank you a lot.
Yes.
Sorry.
Yes.
Because I've heard my colleague say that he wishes the witness to adopt the affidavit. At this point in time, I want to raise an objection
Yes.
in terms of that affidavit. An averment made that the third respondent's brother, once Dunstan O'Malley's, was at the Bonyinyu investigation school. And he goes on to say issues in relation to that. Now, marrying that paragraph of the affidavit with paragraph 80 and 87 of the petition,
Just a moment. and
80 and 87 of the petition. My Lord, these are averments in relation to a person who has not been made a party to this petition. I wish to invite the court to strike out those paragraphs, that is paragraph 37 of the supporting affidavit, and paragraph 80 and 87 of the petition, and these are the reasons.
Just a moment.
My Lord, the reasons why we are contending to that is that the parliamentary and county election rules 2017, Rule 2 thereof, Rule 2 of that, the elections, parliamentary and county elections petition rules 2017, indicates who can be a party in an election petition. And it goes on to say who the respondents could be. And specifically, I want to invite the court to that Rule 2 on interpretation, Part B. That is the last paragraph before Rule 3 comes into play. It says the persons who may be made parties to an election petition are, among others, any other person whose conduct is complained of in relation to an election. My Lord, this entire petition again has had a claim or an accusing finger at one Dunstan Omari. Dunstan Omari is not a party in this petition. Dunstan Omari is not going to have an opportunity to have a rebuttal on whichever allegations that may be leveled against him. Him having not been made a party, it is not available for the petitioner to now come up with an averment which is on off and proceed to adversely mention a person who is not a party in these proceedings. We therefore kindly urge the Honorable Court to make a finding that the said paragraphs that, as I've highlighted, do not have basis, do not have grounding, and do not have any reason whatsoever why they should be entertained, even as we proceed with the petition. Well, the reason why we are objecting at this point is that he will, if it is not objected to at this point, it will go into evidence and a consideration made by the court, because he will have adopted that which he had presented.
Yes.
So that we don't look unstructured. Kindly, I wanted to scratch the surface so that my able assistant here, Mokua, can feed the flesh onto that skeleton that
I thought you should just address me instead of asking this to just address me on that conclusively so that I invite Mr. Moturi if he's objecting.
Now, we did respond. We did respond, and I want to add that Mr. Dunstan Mari is being accused in this court, in this petition, and Article 50, Sub-Article 2 of the Constitution, will be violated if Mr. Dunstan Omari Mr. Dunstan Omari's name is dragged into this petition. He will not have had fair trial by the fact that his name is being presented here. There is the presumption of innocence, my Lord. And this charge of a petition against him will therefore have proceeded without him ever tendering or giving any defense unto his name.
Yes.
Unless that is expunged, my Lord, there is going to be a violation.
I think point is taken.
Thank you.
Unless there's something else you want to add.
I think the board has gotten this one.
Mr. Moturi?
Yes, my lord, very briefly, just one more aspect of that objection. This court has powers to make a determination whether or not an election offense has been committed. And I've looked at the accusations against the named person, which border on commission of an election offense. And as submitted by my learned friend, Mr. Mberi, him having not been named as a party in the petition highly prejudices his position.
Dunstan or Dunstan?
It's
Dunstan.
Dunstan, not Tom.
Dunstan.
and therefore there is a risk that he may be condemned and harmed. On those grounds, I associate myself with the sentiments expressed by the objecting counsel.
I don't know whether the petitioner can be allowed to sit.
It's okay.
But I'm
You
sorry.
can sit, as we hand over this issue. You can have a seat.
My Lord, I'm surprised that this is even an objection that the court should entertain and possibly even make a ruling over. This
Just address it. Don't be surprised, just respond.
In all fairness, my Lord, this is not an objection that the court should entertain. And the reason why I'm saying so is that the petition is wholesome. And if you look, my Lord, and read that paragraph 80 that is being sought to be expanded, it says that the third respondent's brother, one Dunstan Omari, in a video clip, which is an extra, is seen being on a ballot box and
So why don't you,
every
instead of
individual.
reading the paragraph,
Yes.
I think the best thing is to respond to what they have said, that somebody is being condemned and yet has not
He
been
has
named.
not been condemned, my Lord. He is not a party and cannot be a party. We are bringing in the agents, servants, assignees, or so to say, of the third respondent, my Lord.
Yes.
Having been served with the petition, nothing could have been easier for Mr. Omari than to seek them to be enjoined as an interested party or swear an affidavit like the other people have sworn opposing the averments that are contained here so that he can come as a witness. The petitioner has sworn on oath that he saw this gentleman by the name of Dunstan Omari.
That is no evidence, my lord.
He is here.
I think the best thing, confine yourself, Mr.
My Lord, I'm responding. I'm
Yes,
responding.
I know you are
How will I
responding.
respond if I don't mention? Because it's in the affidavit that they seek response.
None of them touched
I don't know how.
on the substance of the contained in the paragraph. All they were saying is that the import of those contents. And I think that's what you should be taking as the import.
Then what I'm saying, my Lord, is that the orders that are being sought are not against that named individual. He cannot be brought in as a respondent when the petitioner is present and ready to be cross-examined on the contents of his affidavit. Considering that the petitioner is available for cross-examination and that individual had an opportunity to either swear an affidavit in response to the petition or come in as an interested party, no prejudice will be suffered if you disallow the request. The only nexus that we are seeking to link with the named individual is the fact that he is a known agent of the third of respondent.
My lord, that is evident now. We are on the issues of law.
Further, my lord,
Yes.
there has been no case law, if we are talking of law, no case law has been submitted to you in support of this very drastic application that you are being told to adjudicate upon. Meaning there has been no single order that has been granted in Kenya since litigation began. You are being asked to make similar orders for the first time since the world began. Disallow that application, my lord, purely because it's malicious, made in bad faith, and meant to further delay these matters. That's all.
My lord, from our team,
Sorry?
from our team,
You don't, I thought you have the...
it is my objection, my lord. It was my objection.
Oh, it was your objection.
Yes,
I'm sorry. I'm sorry.
From my team, I want to invite my able assistant Chandra to address court in response.
Yes, Mr. You want to go
Chandra
on?
Kwamboi.
Thank you.
Yes.
Yes, Madam, first I begin by highlighting that in all fairness, in election matters we do not have an interested party, and therefore for that reason, Mr. Dunstan Omari will not have invited himself to the court proceedings as an interested party. Secondly, my lord, the very definition of a respondent as defined under the election rules 2017 is a person against whom the conduct is complained of.
Yes.
My lord, the mention of the name Dunstan Omari is to complain about his conduct or involvement which, my lord, in the understanding of the petitioner, affected or had an implication in the electoral or the election process. So to that extent, my lord, to that extent, my lord, unless he is a party to the current proceedings, the very mention of his name, if entertained by the court, my lord, will, in other words, be an invitation of the court to participate in the violation of his rights as someone who is accused of having interfered, if at all, with the electoral process. Lastly, my lord,
Yes.
my lord, this issue is not novel. If allowed, my lord, there is a preponderance of jurisprudence on this issue. Courts have determined a similar issue. in any event, my lord, the court is enjoined to promote the rules of natural justice. So that, my lord, fairness
Yes.
fairness, my lord, is achieved through the court proceedings. The court is given an opportunity, my lord, of hearing all parties. My lord, that is all as far as the Uganda is concerned. We humbly pray, my lord, that any mention of the name Dunstan Omari be struck out from the court proceedings. In any event, my lord, it's not a point in dispute that he was not an agent of that respondent. My lord, just across in Homa Bay, in the Evans Kidero case versus the
It's not a
yes. But my lord, there has been a similar application where the name of the Raila Amolo Odinga is mentioned, and my lord, the court has agreed as much that it violates his very rights. Thank you.
We wish to see that decision.
I think there is a better way of presenting such a decision. There is a decision that has been made.
Yes.
We cannot support.
I wish to see it, my lord.
I think that I've just, I do not think the need to wait for the, and you know, the rules of the.
Yes.
Let me take 2 minutes or not 2 minutes, I think, 5 minutes, so that I do the ruling, and then we proceed.